Hello friends, in the series on the income tax cases, today we will discuss a case which is based on section 147 read with section 148 proceedings on the basis of some searches by the Enforcement Directorate. The issue before the Honorable Punjab and Haryana High Court in the present case was that if some proceedings against the assessee under Income Tax Act are initiated and the basis of that proceedings get wiped out, like in the present case the ED has dropped its proceedings, so in the absence of any independent verification by the income tax department whether the additions made by the department should sustain or not. This issue has been taken up by the Honorable Court in the case of Commissioner of Income Tax versus Sachdeva and Sons, and this case is reported in 478 ITR at page number 594, and the date of the judgment is 11th July 2024. In the present case, the assessment year involved is 1988-89. The facts of the case are like this. In the present case, the assessee is an exporter of rice. There was a search conducted on the assessee on 31st May 1997 by the Enforcement Directorate, and some documents were found by the ED department, and the department has also recorded the statement of some of the officials of the assessee. The Enforcement Directorate issued 6 notices to the assessee on the allegation that the assessee has misdeclared the value of the goods exported by it. But in the case of the assessee, the Enforcement Directorate did not allege that the value of the goods is on the higher side. After some time, the Enforcement Directorate found that whatever the allegations against the assessee were made were not on the basis of the independent evidence, and there was no evidence against the assessee. So the ED dropped the proceedings against the assessee. But in the meantime, on the basis of the ED search, assessment under section 147 was opened in the case of the assessee, and some additions were made for the misdeclared value of the exports by the assessee. When the assessee filed the appeal before the CIT appeal, the CIT appeal allowed the appeal of the assessee for the assessment year 88-89, but did not allow the appeal of the assessee for the assessment year 89-90. When the matter was before the tribunal first of all mentioned that in the present case no independent investigation has not been made by the income tax department before initiating the proceedings against the assessee, and in the present case, since the matter stood settled between the assessee and the ED, so the foundation of the proceedings against the assessee under section 147 does not exist, so the additions should also not be there. The addition should not sustain. When the tribunal allowed the appeal of the assessee, the income tax department moved to the High Court on the plea that the ED has filed the appeal in their tribunal, so the matter should get revived and the matter should be looked with that perception. But when the High Court heard the matter, the court said that in the present case, when the ED has gone further into the appeals, then in the case of the assessee, the ED has gone into appeals for a different assessment year, and the assessment year involved in the income tax proceedings is different. So on the basis of that, the appeal of the revenue cannot be allowed. The High Court was also of the view that in the present case, all the additions have been made by the income tax department just on the basis of the statements recorded by the ED of some of the officials of the assessee, and there was no independent verification or independent evidence collected by the assessing officer for making the additions. So in the nutshell, any addition based on a search which is conducted by another authority without any independent evidence or independent verification is not valid in the eyes of law. At the end of this video, once again I am repeating the name of the case. The name of the case is Commissioner of Income Tax versus Sachdeva and Sons, and this case is reported in 478 ITR at page number 594, and the date of the judgment is 11th July 2024. Thank you, friends.